Hello, my name is Adoración Galera. It's a pleasure to participate in this new edition of ELPIS. My presentation aims to highlight the role of Spanish Constitutional Court as an institution to guarantee a rule of law in the Spanish system and in the framework of European law. I will focus on two key aspects: the composition and competences of the institution, and I will do so from a critical approach of recent aspects those have been legally and socially contested. The core of my approach agree that the idea is of the rule of law is rooted in the European common law and find its fundamental pillar in constitutional jurisdiction. The Spanish Constitutional Court has considered as the basic institutional guarantee of the constitutional rule of law. It is the clearest institutional expression of the supremacy of the Constitution and its direct normative efficacy. It has the role of supreme guarantor of the Constitution. In accord with this profile, and as its first president said, Constitutional Court culminates the system of the rule of law. Its function is to perfect the rule of law in the Spanish constitutional system. This essential task ensures that the action of the state public power in coherence with constitutional norms, and in order to ensure this function, the Constitution has taken care to put in place the necessary guarantees to preserve its independence. Thus, with regard to the composition of the Constitutional Court, it is the only state body in which all the constitutional bodies participate in the appointment of its member, giving special importance to the parliamentary chambers, and the Congress and Senate appoint 8 of the 12 judges, while the government and the General Council of the Judiciary appoint 2 each. The text of the Constitution set the term of office of each member at 9 years in order to dissociate them for parliamentary mandate. Another guarantee for its independence concerns the system of renovation of judges. The Constitutional Court is not renovated as a whole, but by first, so that every 3 years 4 members of court are replaced. For this purpose, the judges appointed by the Congress are considered to form one-third, the 4 appointments by the Senate another third, and the 2 appointed by the government and 2 proposed by the General Council of Judiciary the last third. Deadline and the rigor of professional profile are necessary to preserve the independence and credibility of the institution. During the first years of the Constitutional Court's existence, the renewal of this institution was successful in meeting this requirement. However, the recent legislature in Spain have changed this trend. The most obvious reason is to be found in the very strong parliamentary majority required for the appointment of the members of the Constitutional Court, like those of the General Council of the Judiciary, namely 3/5 of the chambers. This requirement introduced with the aim of forcing a compromise between the majority and the minority in each chamber. However, this has resulted in the infraction of the constitutional and legal deadline for renovation, which is an unacceptable result under the rule of law. In fact, one of the issues that has had the most political and legal clamor during the last years has been precisely the renovation of the Constitutional Court. The last renovation, which culminated in December, took place 6 months later than the constitutional deadline. On this occasion, it was up to the government and the General Council of the Judiciary to appoint the judge. However, the political dialogue over the renewal of the General Council of the Judiciary members since 2018 made it impossible for the General Council of the Judiciary to appoint the two judges of the Constitutional Court. In attempt to unblock this situation, in June the government promoted a legal reform to allow the General Council of the Judiciary to appoint it two judges of the Constitutional Court. The forceful political and judicial reaction to this legislative measure even extended as far as the Constitutional Court itself. Moreover, with an unusual decision made by a political confrontation, the Constitutional Court suspended the legislative procedure in the Senate in answer to the protection required by the main opposition party. The situation is finally unblocked. However, there is no doubt that the experience should not be repeated. This we want to maintain the public authority and legitimacy of the institution that guarantee the constitutional system. As the doctrine said, it is essential to immediately restore the central and autonomous role of the Constitutional Court, return to a dynamic of dialogue and internal consensus within the court, and separate it from the political battle. On the other hand, it is also interesting to recall the lasting change in the competence of the Constitutional Court as guarantee institution of rule of law. In particular, the two reforms of the Constitutional Court Act approved in 2015 after the negative political and social consequences generated after the ruling of reform of the Catalan Statute, another of the most delicate moments for the public authority of the Constitutional Court. The first of these reform is going to restore the prior appeal of unconstitutionality for draft Statute of Autonomy. This appeal returns now to the sphere of the competence of constitutional control. The second reform of the Constitutional Court Act introduced a specific measure for the enforcement of constitutional court ruling as a guarantee of the rule of law. Thus, the court may impose coercive sanctions in order to suspension of the authority or public employer responsible for the non-compliance or order the government to carry out the substitutive execution. However, this interesting measure raised some doubt, first because it transformed the nature of this court, which is not part of the judiciary, and secondly, the same distrust it seems to show toward the system. Finally, I would like to refer briefly to the compromise of the Spanish constitutional jurisdiction with the rule of law in the European context. It is worrying how the presence of a liberal regime is weakening European values and the rule of law even through the Constitutional Court. It would therefore be interesting to look back to the procedural element that made the European Union grow as a community of law, to look at the primacy of European Union law, the role of Court of Justice of European Union, and of course the role of Constitutional Court in wielding the Union as a community of law and common values. The Spanish Constitutional Court, on this point, has demonstrated its commitment to respect and guarantee European law since the first declaration in 1992 of the ratification of the Maastricht Treaty, and secondly, in the declaration of 2004, when it pronounced of the compatibility of the Constitution, with the Spanish Constitution, with the European Constitutional Treaty. In both declarations, the Court assumed the primacy of European law based on the contrast with constitutional supremacy. The Constitutional Court has interpreted the Spanish Constitution as an door open to the project of European integration, and with it to the protection of the principles and values that identify it. As the President of the Court of Justice of the European Union said, the European Union is first and foremost an union of values, values that are shared and safeguarded by the Constitution of the member state. In addition, here, the role of each granting institution is decisive in order to validate and respect for the rule of law as one of the hallmarks of the European Union identity. Thank you very much for your attention.